Today we have to talk about strategy. Part of my goal on this channel is to articulate strategic considerations in support of what I consider to be my client, which is the Second Amendment's right to keep and bear arms. Okay? Sometimes that means we have to take strategic losses or strategic setbacks to win the ultimate war. I want to discuss this in the context of the recent mixed decision, some wins and some losses, in the California and the Hawaii quote-unquote sensitive places laws that the Ninth Circuit panel in a 3-0 decision came up with, where they allowed for some sensitive places to stand in Hawaii and California and for others to fall by the wayside. I want to talk about what I think should happen next in that case strategically and why I think what I think. Let's talk all about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. For those of you who already have copies, feel free to leave a review on Amazon. If you don't have a copy, check it out on Amazon.com. All right, folks, so this is going to be a slightly difficult video because I'm going to deliver information that you may not like. And that is sort of sometimes I have to do what I have to do because I view our right to keep and bear arms as so important that sometimes we have to make decisions that are uncomfortable or that we don't really like. And I want to talk about what I think should happen next in this sort of complicated case out there in the Ninth Circuit Court of Appeals in San Francisco, dealing with whether or not to seek cert review by the U.S. Supreme Court or to seek en banc review by the United States Court of Appeals for the Ninth Circuit by the court in its entirety. In the cases of Wolford and Hawaii Firearms Coalition versus Lopez, as well as the related California-based cases dealing with quote-unquote sensitive places laws, the Firearms Policy Coalition versus Banta, and Reno May et al. Versus Banta as well. Now, just as a step back, last week, there was a decision by a 3-judge panel in the U.S. Court of Appeals for the Ninth Circuit based in San Francisco that oversees a lot of those left coast states, including Washington, Oregon, and of course Hawaii, among others. And it was 3-0 in a split decision dealing with the constitutionality under the Second Amendment of so-called sensitive places laws. And just to jog your memory, what a sensitive place is a euphemism for a government-mandated gun-free zone. So even if you have a concealed carry permit in Hawaii or California, there are still no-go zones that are government-mandated gun-free zones, even for those people with permits. Now, the Ninth Circuit in a 3-0 decision took a consolidated appeal of the sensitive places laws in California and those in Hawaii. And this is basically what they found in a very, very fundamentally flawed decision. I agree. They basically said that the following areas you could not ban guns in. That would include financial institutions and banks, parking lots, shared with government buildings, hospitals and similar medical facilities, public transportation outlets, gatherings that might require a permit, places of worship such as churches, and the so-called vampire rule in California, which is the default no carry rule that says you can't carry a gun into a private place without first getting permission. Those were ruled to be unconstitutional under the Second Amendment, but in contrast, there were a lot of terrible losses to the right to keep and bear arms because this 3-judge panel in a 3-0 decision upheld sensitive places laws in the following areas. They said you couldn't bring guns under the laws, and these were constitutional. You couldn't bring guns into bars and restaurants, provided that the restaurants served alcohol. You couldn't bring guns into beaches, parks, and similar places, playgrounds, youth centers, athletic facilities, casinos, stadiums, public libraries, zoos, museums, and the vampire rule the vampire rule in Hawaii that says you cannot carry guns onto private property without first and foremost getting permission from someone there, meaning a property owner or manager, that was sustained and allowed to stand despite the existence of the Second Amendment. Okay, now, mixed decision, Probably better for California gun owners than Hawaii gun owners. I would probably agree with that. The question is, what should the lawyers do and the clients do next? Now, I'm going to tell you what I'm going to recommend, and I'm going to tell you some of the pressure that may be on some of those lawyers and those clients and those parties in those cases. It is clear to me, in my strong opinion, that the right answer here is that the lawyers and the parties in this case, the Second Amendment plaintiffs, should simply go back down to the district court and try to get a final judgment as fast as possible. Because I want to remind everyone of this. This appeal arose from the granting / denial, depending on the case, of a preliminary injunction. In other words, the Ninth Circuit last week ruled in these cases in the context of a motion for a preliminary injunction. None of these cases that I just described were arising from appeals from a final judgment. Thus, everything I just said in these cases is of what's known as an interlocutory nature, meaning it's in the middle of the case. This is a very big deal because, as you know, as we've learned, not just what I said, but if you look at what's happened over the last several years, the United States Supreme Court historically, and it's also the case now, does not like to hear cases that are in an interlocutory posture, which means they don't want to hear a case before it is completely 100% final. Now, the reason why that is because the U.S. Supreme Court is a very special court. What matters when a Supreme Court hears a case is not only who wins the case or who wins the argument, that's very important, of course, but it's equally important, if not more important, how the party wins or loses. It's the doctrine that's set forth, the way to interpret the law, what it means that's going to carry forth into the future that is equally important. And because the Supreme Court only hears 70 cases a year, they want to make sure they have complete information that's been fully percolated and all the arguments have been developed and all the facts have been developed. They want to have all the readily available information in their fingertips so they can make the best possible decision, not only about who wins the case, but also what the law should be, the doctrines that should apply, the way to interpret the law, and blah, blah, blah. They want to get all that right. And the best way to get that right for a long term, because remember, we're going to have to live this for decades and decades when they make a decision usually, is they want to have all the information. And if a case is on an interlocutory basis, it means the case is not yet done, which means there's more factual development that might have to take place. There's more legal analysis that might have to take place. And the U.S. Supreme Court doesn't like to deal with any of that until all the information is available to them, because they don't like doing anything on incomplete data, because they may miss something by mistake that would otherwise have come to light if they waited until the case was over. So the reason why this is important to these cases of Wolford, Hawaii Firearms Coalition versus Lopez, Firearms Policy Coalition versus Banta, Reno May versus Banta, is because this appeal that was a mixed result is on an interlocutory basis. Which means there's no way, in my opinion, that this case in this posture on this appeal is going to go to the U.S. Supreme Court. The Supreme Court will not grant cert. Why is that important? Because it's a waste of time and money to seek cert now because it's going to be denied. So don't do that. So the only possibility is you can either take your lumps, go back down to the district court and finish off the case, get a final judgment, and then come back up on an appeal, or you can seek en banc review. Now, if the plaintiffs seek en banc review, who are they seeking en banc review from? We know who it's from. It's the Ninth Circuit Court of Appeals, which is absolutely 100% a crappy Second Amendment anti-gun court. They're so bad that you've watched my videos about how that court manipulates not just the law, but they manipulate the process and the procedures associated with en banc review, how they issue decisions, who sits on those courts, and so on and so on. They do everything in their power to throw the Second Amendment under the bus. So do we really think that this split decision, some good information, some bad information, some good stuff, some bad stuff, do we really think we have a legitimate shot a real shot to improve our plight as gun owners in Hawaii or California if you seek en banc review in the Ninth Circuit Court of Appeals. It's like you're throwing yourself upon the mercy of Kamala Harris and Joe Biden over gun rights. It's simply not going to work. But what will happen is one of two things. You're not going to win, in my view, on en banc review, right? The only two things that can happen is, one, the en banc court will make it worse for you because they will explain in greater detail why you should have lost the case or on these other issues, or they might expand the number of sensitive places that they think are sensitive, and they may actually make it worse for gun owners in California and Hawaii because the en banc court is not going to be any better than the 3-judge liberals in the panel. It's not going to get better. They won't allow that, in my view. And to make things even worse, you're delaying and delaying and delaying your ultimate goal, which is to get your case or cases before the United States Supreme Court. Because every day that you're messing around in the Ninth Circuit en banc is a day that you're delaying the ability to get to the U.S. Supreme Court. So if you seek en banc review by the Ninth Circuit Court of Appeals now, and they grant it, you're looking at over a year before you get a decision from the U.S. Court of Appeals from the Ninth Circuit en banc. And then you're going to get a decision that is not going to be better for you, in my view, because it's the Ninth Circuit, right? It's not going to get better, may get worse, but no matter what happens, you're going to be a year down the chessboard, a year into the future. And then what happens after that year plus? That case will then, at that point, go back down to the district court for further fact-finding, further legal analysis, and further litigation. And then after another year, you'll get a final judgment, and then you'll start the appeal process all over again. So what have you really done? You've done nothing more than literally delay the time that you need and want to rush out and get right. You want to get to the U.S. Supreme Court, and all you've done is delayed the ability to get to the U.S. Supreme Court by a year or more by seeking en banc review from a court that's terrible on guns. So to me, there is no upside to the Second Amendment plaintiffs seeking en banc review in these cases. Let me be very clear about that. So again, I want you to understand my thinking on this. Because again, whether you disagree with me or not, that's fine. But I want everyone who's watching this video to kind of understand the thought process that needs to go into decisions whether or not to seek cert from the U.S. Supreme Court, which is a waste of time and money because it's going to get denied because you're on an interlocutory basis, or to seek en banc review. But again, you're seeking en banc review from the Ninth Circuit Court of Appeals that we know and everyone who watches my videos understands is anti-gun terrible. So the odds of this 3-judge panel being totally out of sync and somehow worse on guns than the overall Ninth Circuit is unlikely. So you're either going to get the same decision or a worse decision. And no matter what you do en banc, it's going to take a lot of time and money to litigate there when you're better off just going back down to the district court and getting these cases resolved as fast as possible. And I'm sorry, this is probably not going to be liked by gun owners in California and or Hawaii that want to be aggressive and vindicate their personal rights. And I am sympathetic to you and to them. But the reality is, it's probably not going to get better, and you're not going to get the relief you need until the Supreme Court steps in on the sensitive places question. And that's going to take a couple years no matter what. So buy yourself the best possible outcome, which is to get to the Supreme Court as fast as possible. And going down the en banc path is unlikely, in my opinion, to get to the U.S. Supreme Court on the sensitive places question as fast as possible. And it's unfortunate that our brothers and sisters in these blue jurisdictions have to suffer the consequences and have their rights being, infringed upon on a constant basis. It's terrible, and I hate to see it. But again, sometimes, in a war, there are situations that just cannot be helped and sacrifices and losses that you have to suffer because you're in a war, and there are no shutouts in wars. There are no shutouts in litigation. There are no shutouts in these kinds of fights. And I like to bring better news to our gun owner friends in Hawaii and California, but I'm just telling you how I see it. Obviously, I'm sure the lawyers and the parties and the organizations and all the other people involved will have their own views and will make ultimately what they think is the best decision. But I want everyone to understand what I think, and I want everyone to understand why I think what I think, because regardless of what happens, it's helpful to understand how to think about these problems, because this is not the last time this kind of thought process is going to have to be considered by the Second Amendment movement. So you may as well understand the factors and things that go into consideration in making a strategic decision in support of our right to keep and bear arms. All right, folks, hope you enjoyed this today. Make sure you follow me on X at 4Boxes Diner, and we will see you again very soon, I hope, at the 4Boxes Diner.
Orders up. Table 2A.